If you're navigating divorce or separation right now, you're probably feeling overwhelmed, uncertain, and maybe even a little lost. You're in the right place. This is the Soft Landing Divorce Podcast, where we prove that even in the midst of ending a marriage, you can move forward with dignity, clarity, and yes, peace. But here's what makes us different. Ken and Sarah are going to share solutions and strategies that the divorce industrial complex never talks about. Today, they're diving deep into how to master your divorce case without crippling legal fees, even if your bank account is running dry. These are the approaches that can save you time, money, and emotional turmoil strategies that traditional divorce professionals won't tell you exist. What you'll discover today will open your eyes to things unseen by most people going through this process. Whether you're just starting to consider separation or you're deep in the legal maze, our goal is simple: to help you and your children land as softly as possible on the other side. So grab your coffee, get comfortable, and let's dive in with Ken and Sarah as they reveal what the industry doesn't want you to know.
Hey everyone, welcome back. I've been saving something extra special just for you today. We're going to do a deep dive into something that honestly confuses the heck out of most people going through divorce. I'm Ken, and we're here on the Soft Landing Divorce Podcast. And man, today we're talking about how to master your divorce case without crippling legal fees, even if your bank account is, well, let's just say running a bit dry.
Hey, Ken, and hey, everyone listening. I'm Sarah Bates, Certified Divorce Specialist at Naked Divorce Filer by DTSW, and honestly, this topic gets me super excited because it's like the foundation of everything. I mean, if you don't understand whether you're the applicant or the respondent, you're basically walking into court blindfolded.
Right. And Sarah, you've got over a decade in Canadian family law. You've been a freelance law clerk. So when you say this is foundational stuff, I'm really curious. Let's start with the basics here. What exactly is an applicant versus a respondent?
Okay, so think of it this way. The applicant is basically the person who says, I've had enough, I'm taking this to court. They're the ones who file the paperwork, who get the ball rolling. Sometimes people call them the plaintiff, but in family law, we usually stick with applicant.
So they're the ones who actually start the whole process.
Exactly. They're filling out that divorce application, submitting it to the court, serving it to their spouse. It's like they're the director of this whole legal movie, if you will. And then the respondent, well, they're the one who gets served those papers and has to, respond.
Mm-hmm. So the respondent is basically on the receiving end of this whole thing?
Right. But here's where it gets interesting, Ken. A lot of people think being the respondent means you're somehow, I don't know, the bad guy, or that you're at a disadvantage. That's totally wrong. The respondent has just as many rights, just as many opportunities to present their case.
Seriously? Because I gotta say, if someone served me papers, I'd probably feel like I was already behind the 8 ball.
I know. It feels that way. But listen, the court doesn't care who filed first. What they care about is the evidence, the facts, what's in the best interest of any kids involved. The person who initiates isn't automatically going to win anything.
That's actually pretty reassuring. So what are we talking about in terms of rights and duties? Like, if you're the applicant, what's your job here?
Okay, so as the applicant, you've got some serious responsibilities. First off, you got to file that statement of claim. That's basically your roadmap of what you're asking for and why. You need to respect court deadlines, and I mean religiously. Miss a deadline, you could be looking at case dismissal or even contempt charges.
Wow, that's pretty serious stuff.
It is. And here's the thing. You also have the right to seek legal advice to present your case effectively. But with that comes the duty to, actually prepare, organize your evidence, your financial records, witness statements, all that stuff.
And what about the respondent? Are they just sitting there waiting to see what happens?
Oh, no, no, no. That's another huge misconception. The respondent has the right to respond, obviously, but they can also defend their position, present their own evidence, even file counterclaims. They're not just some passive participant in this process.
So they can actually go on the offensive too?
Absolutely. And they have to respond within a specific time frame, usually determined by the jurisdiction and the nature of the case. In Ontario, for example, if you don't respond, well, that's when things can go really sideways.
What do you mean by sideways?
Default judgment. Basically, the court says, well, if you're not going to participate, we're just going to decide based on what the applicant is telling us. And that can be devastating. You forfeit your chance to present your side of the story.
That sounds like a nightmare scenario. So if you're served papers, you absolutely cannot ignore them?
Never, ever ignore them. I've seen people think, oh, if I just don't respond, maybe it'll go away. No, it won't go away. It'll get decided without you, and you're not going to like the outcome.
Okay, so we've talked about these misconceptions. What's the biggest myth you hear about applicant versus respondent roles?
The biggest one, that the applicant has some kind of automatic advantage. People think, oh, they filed first, so the court's going to favor them. It's not true. The court is looking at facts, evidence, what's fair. They don't care who pulled the trigger first.
So it really comes down to preparation and evidence, not who filed first?
Exactly. And you know what? These roles can actually shift during the process. Someone might start as the applicant for divorce, but then the other party files for spousal support or child custody. Suddenly, they're both applicants and respondents on different issues.
That's wild. So it's not just this fixed thing throughout the whole case?
Not at all. Family law it's complex, it's fluid. What matters is understanding your rights and responsibilities in each role and making sure you're actively participating in the process.
For everyone listening who might be facing this situation, what's your biggest piece of advice?
Don't let the labels scare you. Whether you're the applicant or respondent, you have equal opportunities to present your case. The court's job is to be fair, to look at all the evidence from both sides. Focus on preparing your case, not on whether you filed first or second.
And if someone's feeling overwhelmed by all this?
Get help, whether that's a lawyer, a divorce specialist like myself, or even just the court assistance programs. You don't have to navigate this alone, and honestly, you shouldn't. This stuff is complicated, and there's no shame in admitting you need guidance.
So as we wrap things up here, Sarah, I think what really strikes me is that this whole applicant versus respondent thing, it's really just about procedure, not about who's right or wrong.
You've hit the nail on the head, Ken. It's purely procedural. What really matters is the evidence you present, how well you prepare, and whether you're actively participating in the process. The judge doesn't care who started it. They care about what's fair.
And on that note, for everyone listening, here's something to think about. If you're facing a family law situation right now, whether you're thinking about filing or you've already been served papers, how might this understanding of these roles change your approach? What might you do differently now that you understand the real dynamics between applicant and respondent in Canadian family law?
That's such a great question to sit with, because when you realize that your role doesn't determine your outcome, it really shifts how you prepare, how you think about the whole process.
Absolutely. Until next time, everyone, keep asking the hard questions, keep learning, and remember, knowledge really is power when you're navigating family law. Stay curious, keep those questions coming.
And that's a wrap on today's episode. Divorce doesn't have to be as complicated, costly, or drawn out as the industry often makes it seem. You have more choices than you've been told, and more strength than you may realize. The question is, when it comes to dissolving a family law case, are you operating from fear, confusion, or full control? We believe you deserve to be in the driver's seat. If today's conversation resonated with you, here's what we'd love you to do. First, Hit that subscribe button for the Soft Landing Divorce podcast. These strategies could change everything for your family. Second, leave us a review to help other people who desperately need this information find us. And if you know someone navigating separation or divorce, share this episode. Sometimes the kindest thing we can do is show someone they're not alone, and there's a better path forward. You'll find all our resources and connection links right in the podcast description. Remember, we're not just here once a week. We're building a community of people who believe divorce doesn't have to destroy families. We've got so much more to share in the weeks ahead. Until then, keep moving toward your soft landing. You've got this, and we've got you. That's Ken and Sarah. See you next time. Disclaimer: this podcast provides general information only and does not constitute legal advice. Consult a qualified legal professional for guidance specific to your situation.